Okay, let's settle the down and work out what's going on here. I get it. The government stenographers told you that Reed's entire appeal has been denied, but that's not what happened. Let's start from the start. The doctrine of exhaustion means that the process of the appeal has to start at the trial court, because that's where the criminal case began. So before the federal courts can get involved, Karen first has to exhaust state appeals. Under US law, you can't go straight to the federal court. You have to exhaust all options in the Massachusetts state court system first. We know she did that because she filed a motion to dismiss the charges, and then she appealed that denial all the way through to the Massachusetts Supreme Judicial Court, and the SJC ruled against her. Now that her state options are exhausted, she's now allowed to bring her claim to the federal court. Under 28 U.S.C. Section 2241, a special kind of emergency habeas petition used to challenge unlawful pre-trial detention or constitutional violations. She asked the U.S. District Court for Massachusetts, this is the federal habeas court, to stop the retrial on double jeopardy grounds, and it denied her petition. She couldn't just skip this part of the process and run off to SCOTUS straight away. This is the structure of appellate law. The next step was to appeal to the First Circuit Court of Appeals on the habeas petition. The First Circuit heard her appeal. It was not denied or dismissed. It simply ruled against her on the merits, saying the retrial does not violate the Constitution. The final decision in this document, both at the start on the first page and at the end on the last page, was denying her motion to stay the retrial as moot because their ruling ended the case at their level, not at the SCOTUS level, at the First Circuit level. That completes exhaustion of all her other options, so she can now bring a claim to the US Supreme Court. You can't just skip all of these steps and go straight to SCOTUS. Now, and only now, Karen Reed is eligible to file a petition for writ of certiorari with the US Supreme Court. SCOTUS will then decide whether to review her appeal. The issue is, the headline saying Karen Reed's appeal denied make it sound like she wasn't allowed to appeal, or that she tried and failed to go to SCOTUS, and that's completely false. Her appeal to the First Circuit was real, valid, and ruled upon. The denial of a motion to pause the retrial is being confused with the denial of the appeal itself. Where the misunderstanding comes about is not just in the way the headlines are saying it, but misunderstanding of the exact legal process required. Step 1 is the state court. Step 2 is state appeals. Step 3 is the habeas petition. Step 4, appeal to the First Circuit. Step 5, she is now eligible for SCOTUS. Without any of those previous steps, she was not eligible for SCOTUS. The First Circuit ruling doesn't mean her appeal was denied, just the stay of proceedings. It means her federal appeal was heard and lost, and now SCOTUS is the next step. Some have pointed out that there's a step missing here, that an en banc rehearing at the First Circuit is the next step. However, en banc is typically reserved for cases involving exceptional importance or when the panel decision conflicts with precedent. Karen is not required to, in order to proceed to the US Supreme Court, request an en banc hearing. It's a strategic decision, not a procedural necessity. That is, it plays no role in the doctrine of exhaustion or the structure of appellate review to get your way to SCOTUS. Whether or not SCOTUS would frown upon skipping that step is completely beside the point. The point is, this First Circuit ruling does not deny Karen Reed's appeal. The very slim chance of SCOTUS actually wanting to hear the appeal is completely beside the point. The Federal Habeas Court gave Karen Reed leave to appeal to SCOTUS, and nobody has denied that. This document says very clearly on the first page and the last page, The habeas court or the district court's decision is affirmed, and Reed's motion to stay the state court proceedings pending appeal is denied as moot. In legal terms, moot just means there's no need to pause things anymore because the appeal before them is done. Their ruling, upholding the federal habeas court, ends the case at their level. Therefore, they have no say over any other levels, including SCOTUS. What the First Circuit affirmed was the federal habeas court's decision denying Karen Reed's habeas petition, not her appeal. Nor does it preclude her ability to file a motion to stay at the SCOTUS level. The point of making a motion to stay at the First Circuit level, pending further appellate review, was most likely to preserve time to file their petition to the Supreme Court without the retrial going ahead in the meantime. The wording of the First Circuit Court matters. It says, Reed's motion to stay the state court proceedings pending appeal is denied as moot. The language suggests the First Circuit's role is over, so they've got nothing to pause. But it leaves open the possibility that SCOTUS could grant a stay if and when the petition is filed. The bottom line is, it would make little strategic or procedural sense for the defence to seek a stay without intending to take the case to SCOTUS. The motion signals the next appeal is either already filed or imminent. The First Circuit's denial of a stay does not mean the appeal was procedurally invalid. It simply means the First Circuit is done with its part, so that motion no longer applies at the First Circuit level. So, what happens next? The Dream Team can now appeal to the US Supreme Court if they haven't already filed it. That's probably what they're doing right at this moment. They'll file a petition asking SCOTUS to hear the case. They also may ask SCOTUS to pause the retrial until that's decided. So, at the end of the day, all this means is that Reed's appeal was not denied, and saying it was is misleading. The stay was denied only because the First Circuit is done, and SCOTUS is next for the actual appeal. This isn't over yet. We'll now be watching the docket for the SCOTUS appeal to appear. I get it, there's slim pickings at SCOTUS level. It will be an interesting read, to say the least.